Welcome to the Laughing Litigator.
Hey everybody, welcome into an all-new episode of the Laughing Litigator with attorney Ray Hsu. I am your host, Mike Leon. Ray here is a California employment lawyer who has represented both employers and employees, so he sees how the wage and hour rules affect people on every side of this system. Today's episode, Ray is going to be bringing two direct questions for the California Labor Commissioner. Questions about worker protection, penalties, and the real world behind enforcement. Ray, it's good to see you as always. You said this episode began with two questions you wanted to ask to the Labor Commissioner. So what made you want to put those questions out in the open instead of keeping them inside the legal world?
Thank you for having me, Mike. These are not questions for a deputy counsel at the Labor Commissioner office. They are questions for the top decision maker, the person whose role is primarily political and policy driven. So here are the questions. Dear California Labor Commissioner, or whoever is brave enough to hold that office in 2025, I have two questions. I've represented employers who feel crushed by paperwork and employees who suffer outrageous wage theft by their employers, including representing illegal immigrant workers. Here are the two questions to discuss. How do we enforce California Labor Code that promises protection to illegal, undocumented workers who aren't even supposed to exist in the system based on some other government agency? And question number two, does the Commissioner's office still believe education can replace punishment? Or have we accepted that the only language people understand now is penalties?
It's a great question. Let's harp a little bit more on the first one, right? Because California law promises protection to undocumented workers, even if the government agencies treat those workers, like you said, if they don't exist. So how should people understand that conflict between the different parts of the system?
So historically, people didn't really have to worry about the scope of that protection because the California Labor Commissioner positioned the agency very clearly, or even sometimes perfectly, I would say. If a worker files a claim, there's a conference and possibly a hearing. Immigration status simply doesn't matter. For wage and hour violations, it's irrelevant whether a worker is documented or undocumented. I'm raising the question now because of recent ICE-related protests and something I noticed when I visited a DLSC or Labor Commissioner's office here in Southern California a few weeks ago. They had these small red handout cards designed to help certain individuals dealing with ICE encounters or arrests. To be clear, I have no objections to those cards themselves. My question is more structural. If the Labor Commissioner's office starts to advocate for undocumented workers in a way that looks more like nonprofit legal aid, how are employers supposed to fully comply with the labor code, especially when it comes to auditing and compliance? We all know the reality on the ground. Some undocumented workers are paid in cash. Some use fake or borrow social security numbers to get through payroll. I'm not passing a moral judgment, it's just the practical reality employers and auditors deal with. So the real question is this: why would the Labor Commissioner's office give up its neutral enforcement position and tilt toward advocacy in this way? The agency operates under the authority of the Labor Code. That's all we know. And specifically, helping workers respond to ICE enforcement isn't part of that statutory authority under the Labor Code. A government agency without statutory authority to act, I would say, overstep.
Well, Ray, you've represented both sides of the equation on this. So employers that are trying to follow the rules, workers feel invisible, like you said. How does the experience kind of shape the way you've looked at enforcement of undocumented workers?
Before the Trump administration, no difference. But right now, I'll admit it, there were moments when I worried a worker might simply disappear one day. I also had a few employer clients come to me with a different concern. They'd ask, sometimes quietly, whether ICE might pick up certain workers and whether that could somehow make a lawsuit go away. My answer was always the same. Yes, I suddenly felt omnipresent on social media. You saw videos everywhere. But that doesn't mean ICE or USCIS has ever been interested in acting like a hitman for an employment law dispute.
So your second big question that you had for the commissioner was about penalties, and California has tried, education, warning, some outreach. In your view, is the education still working today, or is the system moving towards penalties, like you said earlier, as the main tool?
I really want to ask this question because some of the penalty structures just don't make sense to me. Take heat recovery pay, for example, the issue I talked about in the previous episode. We're talking about situations where workers are allegedly forced to work in extreme heat without adequate shade or water, conditions that sound almost unimaginable, or like modern slavery condition. And yet, if it does happen, the remedy is often just 1 additional hour of pay per day under the statute. What's hard for me to understand is that the same remedy applies to very different situations, like an office worker missing a 30-minute meal break after 5 hours of work, or 10 minutes rest break after 4 hours of work. I'm not minimizing meal and rest breaks claims. They are important. But I genuinely struggle to understand the rationale behind treating very different violations as if they are equivalent, at least from a penalty standpoint. So the real question is, are these rules still about educating employers and correcting behavior, or have penalties become a blunt instrument that no longer reflects the severity or even the reality of what's actually happening on the ground?
Ray, let me ask you, a lot of the times I've heard small business owners say there's too much paperwork involved. They got to fill out too much paperwork, right? And then the workers feel that they're unprotected unless the state takes some type of strong action, like you said. So, how do you think the commissioner can balance those two pressure points at the same time?
Yeah, before they can remedy the situation, I think they need to increase their operation budget first. Hearings now can take years. Decision can wait for another 3 to 6 months. Yeah, they need to get more money, get more people to first.
Ray, what do you think the state can do to kind of reduce the fear element that we've been talking about before? Because the enforcement depends on complaints, right? And a lot of the fear now is that undocumented workers, like you said earlier, will get picked up because of the new administration. So, what do you think the state can do to reduce the fear but still keep the process fair?
I think the state needs to encourage education. And we all know education eradicates or minimizes fear. And it should be for both sides, employees and employers. And I have situation that I have employer client who want to do exactly the same thing that his former employer did to him when he was an employee, not paying overtime, not paying cash without reporting on the payroll, and all kinds of wrong things. Because in his mind, that's exactly what I had when I was an employee. I'm just doing the same, like a cycle. So I think education to break that cycle is very important.
Ray, last point here before we wrap. If the labor commissioner happened to find your pod right now, he or she is listening, what would be one thing you would want them to understand about justice in these wage and hour cases in 2025 and beyond?
Oh, thank you for the question. If the labor commissioner were listening, the one thing I'd really want them to hear is this. Please start to charge filing fees. Justice in 2025 or 26 requires some friction. Right now, the system is almost frictionless. No filing fees, no recovery limits, and extensive free resources like free foreign language interpreters for conferences and hearings. Not even Superior Court, Small Claims Court offers the same level of access. While that was designed to protect workers, it's also being abused by a small number of bad faith or vexatious claimants. Introducing modest filing fees, similar to what superior courts already required, wouldn't deny access. It would restore balance. It would encourage seriousness, discourage abuse, and signal that this is a legal process, not a cost-free pressure tactic or some kind of blackmail tactic against certain supervisor or employer using the labor commissioner hearing process. Justice doesn't mean every claim should move forward untouched. It means the system has the courage to recognize that not every employee is acting in good faith, and that protecting workers also requires protecting the integrity of the enforcement itself. Access matters, but unchecked access undermines justice for everyone. So that's my take on it.
Yeah. Ray, thank you for the time, the insights, breaking all this down. I truly appreciate it.
Thank you, Mike.
And that's it for today's episode of The Laughing Litigator. If you want to learn more about Ray's work in California under employment law, do me a favor, visit rayhsulaw.com today. Thank you to everyone for listening, but don't forget, like, subscribe, leave a review, and comment or share it with someone who needs to hear it. As always, I'm Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.